What happens to your rental properties when you pass away without a will? The courts will decide how to distribute your assets out to your beneficiaries. And so, if you want your rental properties to go down to your spouse, which typically makes sense, people would want their spouse to have those rental properties to financially support themselves for the remainder of their life. You have a couple different options on how you can handle that. The first one is going to be co ownership as joint tenants with rights of survivorship. That way, you each co-own those properties together, and then when one of you passes away, your half of the rental property will automatically avoid the probate process and go directly down to the surviving co-owner or surviving spouse, and then they would have 100% ownership of those properties. Another way that you could do it is to put those rental properties inside of a revocable trust. Those properties will be in that trust while you are alive, and you would have control over those properties as the trustee. When you pass away, your backup trustee will step in your role as trustee and take over the management of those properties to be managed on behalf of your surviving spouse. And they could use rental income to be able to take care of themselves financially. They could sell rental properties to generate cash to take care of themselves financially. They have a couple different options on how they could handle that. And then when your surviving spouse passes away, those rental properties could be passed directly down to your kids and avoid the probate process.